complete forms training today. I know it's a topic that most of you who are experienced attorneys, this might be a little redundant for you. I'm hoping that everyone will gain something from today's training today, but most of the forms that we're going over are things that I wish I would have known as a new attorney, some nuances in some of the forms. So we're going to go over a lot of them. I have printed out the basic forms that we use most often. By no means is this an exhaustive list. So we have, the ICWA 020 form, which is, if you look it up under the Judicial Council forms, it's under its own separate division heading. So you have to go and pull those up under ICWA. You have your juvenile forms, which we use in court all the time. And this is a basic summary of all of them, so you can find them quickly. I would like to say that as we start, when we first meet our clients, I think the most important thing before we even do anything is we ask our clients, have they ever been in this court before? Do they have any other children that they don't have in their custody? Just to be aware. The motivation for this is you might not have to fill out as many forms if somebody else represents this client. You might be able to transfer a case to a department where there's already an existing case. So you won't have to fill out a 170.6 form. It can go to a much better judge. Those are things that you should consider on each and every case. So when you meet with your client, ask them, have you ever been here before? Do you have any other children that are not in your care? If they were here, who were you represented by? So I think everyone should be asking those questions. We need to prevent as many conflicts as possible. So just a piece of advice. We have, as part of some of the forms I have not provided today, obviously we've all seen the mom's paternity form, right? So we all know what this looks like. We filled it out many times. I think that what we need to do is just be aware of what we're writing on these forms. Think about the parties that are involved, who's present at the proceedings. So when you're filling out a mom's paternity form and she's telling you that one person's the biological father, but really the real father she wants you to put on the form is her new boyfriend. You need to be aware of that you should put down whoever the biological father is, maybe somebody else who stepped forward, maybe want to include both names in the paternity form and let the judge make those findings. Those findings are listed on the bottom, and right now, as you're aware, it's really important we provide as much information as possible. So ask questions. If a mother says that a father is identity unknown, you want to ask some questions. Do you have a first name? Do you have an address? Do you have a phone number? Do you have a friend or family? Where does he, where did you meet him? Where did you see him? Is there a place where he works? That's also to prevent you from having to file an Ainsley motion later on in the case when some gentleman appears or some individual claiming to be a parent appears. You want to prevent yourself from having to fill out all this paperwork. You want to ensure that all of the clients have the earliest opportunity to be involved in these proceedings. So ask questions, try to avoid putting identity unknown. It has an impact, an impression on the judges, on minors counsel, and we also don't want our clients to go in there and lose credibility as a result of what they put on this form. I can't tell you how many times clients have provided information that's just, maybe they didn't have all the information, maybe they weren't forthcoming, maybe their attorney was rushed, and later down the line we find out that there could have been another person that is the father, and it just causes a huge mess in a case.
Excuse me for interrupting.
Sure.
But I find sometimes when you ask the parent and they'll look at you and they say, well, I don't want him involved, I don't want him involved. So then I'll give them a little speech. I said, really, you have to be honest, and if you really know and you lie and they find out later because the father comes in and says, what do you mean? I see her every day and she knows. You really lose credibility. So you can tell because they'll sort of hedge and say, well, I don't want him involved anyway. That's a key she knows.
Right.
So
they usually give you indicators. Also, you're signing this under, the client is signing this under penalty of perjury. So it's really important that they're honest with the court and they provide information. So try to list the address if you can, detailed information. Yes.
There's another reason why you get as much information as possible, especially if the child is in foster care. You'd rather have the child with family than
Absolutely. Right, absolutely. You want to look for relatives replacement as well. We have relative information forms. They have not been included today, but just everyone should have seen a relative information sheet. There are two forms. One of them provides a list, you can number as many households, about 4 or 5 on one form. And then there's another relative information sheet that asks about each particular household, who lives in it, and whether there's any criminal history for any individuals over the age of 14.
The second form you give to them, if the caretaker that wants, the prospective caretaker wants the child, they fill it out then and there because they have to sign.
Correct, and most of the court officers only want you to provide, the best, possibility for placement. So you need to review the information with the relatives and find out who is the most viable resource for placement. So the second form is the financial form. I also didn't provide that to anyone today. We've all seen it. We've all had to fill it out. Typically what I do is I provide the information. If there's an address, I make sure it's confidential. I don't have my clients sign the form. Everyone's a little bit different, but I don't know how much my client is going to be charged. I don't know their particular situation, so I usually wait for them to go over that information with the financial office. It should be noted that every client has the right to dispute whatever it is, fees that are assessed that they owe the court. They have the right to request a hearing. And the procedure for that would be they need to request that in the financial office on the 3rd floor. The financial office will contact your court clerk, and the court clerk will schedule a hearing. There are some forms for the financial declaration forms. That is in the JV 130s. So I usually also write non-offending on the form. I'm hoping that in some way, for non-offending client, they may or may not have to be assessed for fees. If the case is dismissed, the parties do not have to pay any court costs. Regarding the financial forms, in those forms, there's an income and expense declaration, essentially. And when your client requests a hearing with the judge, it's not entirely clear whether we are going to be representing our clients in those hearings. I did go over the code provisions. There's nothing that says that we represent our clients in those financial hearings in the WIC code. However, the judicial counsel forms do indicate that the client has the right to be represented by an attorney, and if they cannot afford an attorney, then the court can appoint an attorney for them to represent them in the financial hearing. So I'm not sure which comes first, the financial hearing, the appointment, whether we're involved. But you can guide your client, and I would advise everybody to speak with the director of their firm before they decide to represent a client in the financial hearing, and to receive guidance, because each director might be a little bit different, and they should check with the executive director. All right. So the next form I'm going to go over is the first form that you have in your packet today. It is the 170.6 form. We have a lot of issues right now with 170.6 forms being filed. When you file one, the judges are going to really press you. You're under really sensitive time restrictions. Most of the clients now appear much later for detentions. They're showing up at about 10:30. That doesn't give you a whole lot of time to go over everything, go over the paperwork, all the forms that you need to fill out, and determine whether you're going to file a 170.6. I really urge everybody to fill out and conduct an interview with their client before you just turn in a 170.6 form. A lot of the judges, as soon as it is being transferred upon notification, they're ordering a lot of the attorneys to the new department once it's officially been transferred. I should also mention that when you file a 170.6, you need to remain in the court of origin. A lot of the attorneys are going to different departments, and if you're consulting with an attorney and that is what your firm's policy is, that's different. But you should not be escorting the clients down to each department until you find out where the home court is eventually going to be, your final destination.
Well, what do we do if we're doing 170.6? I have the file, let's say I've talked, I have everything, the petition. I usually, if it goes to another court, don't necessarily take my client, but I take my file so they can see if they want to file it. So you bring your file and then come back to your court.
Right. I think that, you can do that. You can also talk to the fastest way to determine whether there's a conflict or not. I mean, whether you should file 170.6 is to contact your supervisor. They have a really great idea in terms of which cases and what types of allegations some judges might not be best suited to hear.
But the second court, unless if somebody comes in with 170.6, I have to see what the allegations are. I have to read something to see if I'm gonna keep it with my judge. So that file should be transferred to the new attorney, and then if they send it on, then the origin attorney will be in the court, but
The
otherwise
problem we
I
have is that a lot of the attorneys are running around the courthouse and trying to find somebody to consult with. They might not be able to find somebody or track somebody down, and it's delaying the whole 170.6 procedure that this court's implemented. So whether it be, whatever your firm policy is, whether it be to speak with a supervisor, that's usually the fastest method. That's what I would advise. Every firm's a little bit different, so you should talk to the director.
But I do think there should be a universal law that we got a 170.6 on Friday at 3 o'clock. Now, things do happen, it's been to a lot of courts, but I think if it's like 2:30 or 3 o'clock, I think that maybe the origin attorney should come and do it, because it's a real hardship to meet and talk and be, you know, professional, and
That's why we need to
there's
handle
gotta
our...
be like a time.
Right. We need to handle our detentions right away. We need to make sure that we fill out the paperwork right away because, yes, there are delays, but it's not a perfect, situation. Sometimes attorneys are busy, sometimes you're in court. You need to ask for support. So if you feel that you're not able to get to a detention before lunch, you might want to call for some backup, especially if you're in your department where you may have to file a 170.6. You might want to go over the allegations quickly with somebody. And I would just talk to a supervisor because you're going to go through so many courtrooms. I have papered a case and I've been through, 3 or 4 different courtrooms. So you should talk to somebody and get guidance and have them on the phone, text them, after you've described the case, you can text them and they can provide you with guidance in terms of whether you want to paper the next court or not.
Jolene?
Yeah.
I think that 10:30 detention is the worst idea that could have ever happened because the parents show up late anyway.
Right.
And when they show up late to 10:30, we're dealing with people who show up right before the lunch hour. Then we can't really make the assessment because we don't do appointments till they show up.
And that is something that we need to work out, but right now that's what the presiding judge has decided that in order to assist with the parking situation.
But I think that's
But-
also like one of the reasons why papers are being done so late because
Right.
we don't get appointed till really late.
Right. We just need to try to do our best. I mean, that's all we can do. It's not a perfect system.
Is there any chance of getting the paperwork earlier instead of like at 10 o'clock? So that's when the stuff shows up and it's like,
That's an internal issue with
it's like
DCFS, so.
ridiculous.
Yeah, but we don't have any control of the clerk's office.
Right, and also the court officers go through them, sometimes they're not available. Ever since there are layoffs in the court, there's been issues with receiving the paperwork on time. So I have my clients sign the 170.6 form. I go over it with them. I speak with every client about why I'm filing this form and whatever my advice is. Sometimes my clients already know that they're going to sign, they want to file one, so I always discuss it with the client. There have been, in years past, some bench officers decided they were going to reject the 170.6. They brought the client in, asked them, did your attorney go over this information? Some of the clients said no, and in fact, I haven't even met my lawyer yet. So those are some issues we don't want to have happen. That's why I always have, I think the best practice is to have your client sign it. Make sure you go over that form with your client. Also, just be aware of new petitions, new assignments, judges coming over. As soon as you hear of an assignment, you need to think about filing these forms. There are deadlines. Talk to your director if you hear anything like that, or if you're concerned. It's always better to ask than it is to not file one or not think about it. So just go ahead and, every case, just think about whether this is appropriate. It's a new case, new judge. Think about those issues. The next form that we have is the nunc pro tunc. It is Latin for it means now for then. This basically is when we want to correct.
I think the next form is the notification.
Is that the, oh, I'm sorry, I apologize. It is the notification. I did include another form, usually at the arraignment most often. You'll find out that there is a restraining order issued from a different court, from family law. There might be a probate court involvement. And this form will notify those courts that there is a proceeding in juvenile dependency court. Some clerks will fill these forms out themselves. Some clerks will contact the court themselves. but this is for you. I've had to fill them out in some of the departments I've appeared in, and I think it's best practice to ensure that the clerks are notifying the other courts. That way we don't have inconsistent hearings. Some of the clients might still go to the court, and so we want to make sure that we notify them that juvenile dependency is involved and our case is going to take precedent over those other cases in probate or family law. The next form is the number 10. So when you have a situation where the judge makes an order and that order is not reflected accurately in the minute order, the minute order is wrong. That is when you nunk the minute order. There is a form here you can use. You might want to ask your clerk. They're not going to be happy with you, by the way. They are going to be really upset. They got the minute order wrong and they're not really excited to hear about that. You can either write up an attorney order and use this form here and make sure everyone signs it, everyone's in agreement that this is the correct order, this is the order that should be reflected on the minute order. You can sign it, fill it out for the court clerk, and that's pretty much all you need to do. It's similar to a walk-on hearing. Just make sure you notify all counsel. There might be some disagreement. If there is any disagreement about what the order is, and then you would want to walk the matter on to clarify. You might want to ask for a readback in terms of what the orders were during the proceeding. And my next form should be the request for walk-on. So every court clerk in the building and every judge have different preferences in terms of what information they like to have when you're requesting a walk-on hearing. So you need to, when you're assigned to a new department, speak with a clerk and find out if there's a specific form for each department. I have every form, I think, for the entire building, and they're all different. I provided you with Department 414 and Department 416 just to give you guidance. Some attorneys use their own walk-on forms, pleading paper. You can use any of them, but always provide the information on the form that the judge prefers. Some judges want to make sure that all counsel have been notified. Some judges want priority, want dates. So definitely, fill these out and deliver whatever it is the judge wants. Make sure they have that information. You should notify all counsel that you're walking the matter on. Try to resolve the issue before you walk the matter into court. We don't want to have any more, cases on calendar, court congestion. You want to do your best to try to resolve it, and if you cannot resolve it, that's when you need to walk the matter on. Notify all counsel as soon as possible, and once you receive the date, follow up. Make sure all counsel are available. Find out the dates of availability from the clerk and set the hearing on one of those days. Moving on to the next form, and I apologize, there's so many forms here. I'm trying to get through most of them, as many as possible. So the next form you should have, actually, you don't have, it's what I have. It's the 730 evaluation form. Has everyone seen one of these, filled them out? These forms are usually, they should be used after disposition for the most part. They can provide the court with guidance. This is when we appoint an expert. We do that when we want to have DNA testing. There is an address, it's 1140, I believe it's York Court or North Court Extension, Burlington, North Carolina. I'm going to have some stickers printed out, so if you ever have, on the 4th floor ladle room, so if you do need those addresses, you can just grab a couple of those stickers and just put them on here. You need about 3 of these copies. You need one for yourself, because they're going to lose this form. It happens more often than not. You need one for the court, and you need one for the paternity testing, which occurs on Thursday, Friday. I believe it's 11 to 4 on Thursday for children, and Friday 9 to 12. You might want to check on that and see if that's the most up-to-date information. Let's see here. Oh, it's 1440 York Court Extension. The other issue I'd like everyone to know about is most of the new attorneys are tricked into thinking that they have to have a 730 evaluation done pre-dispo, especially with mental health cases. I've had 2 or 3 of my attorneys where the county counselors are requesting a mental health evaluation to be done pre-dispo. We should not agree to that at all. We should not be serving up the, providing them with information that they can use to assert jurisdiction over a client. When we enter a general denial, we're denying the allegations of mental health issues. It's not at stake. If the court intends to exercise jurisdiction at dispo, they can make those appropriate orders. There is a case you should use. If ever the court decided to order it and say, you know what, you can seal this for purposes of disposition, you can cite this case. It's Lori S. v. Superior Court. It's a 1994 case, 26 Cal 4th 195. And basically what it is, by the very fact that somebody may have allegations of mental illness, it's alone does not justify psychological examination of that parent. By denying the allegations of the petition, the parent does not tender his or her mental state an issue. The only finding for assumption of jurisdiction, it basically means that a parent's liberty and privacy interests are at stake, and our aim is to reunify the child, and an expert opinion may be required at disposition, but not at the juris phase or pre-juris. The 730 forms also can go over bonding studies you might want to use for instance, for a contested 2-6. Sometimes experts are appointed to determine about placement or custody recommendations. Also for likelihood of abuse, so if you have an allegation of sexual abuse, or if you have an allegation somebody's suffering from substance abuse or alcohol abuse, the court can order an expert to determine the likelihood that reunification would, benefit the child, and especially if there's no family reunification recommendation, it'll provide the court with some guidance.
However, sometimes, especially with labor, you may want to do your private secret evaluation. Because if you do it through the court, then everybody's going to get it. So I think it's much more advisable for us to do it, and if it's sparkly, great, then obviously I serve them in enough time so they can bring them in. Otherwise, you're opening
A can of worms.
everything up.
I completely agree. It's always better to know what your strengths are and to present the case on behalf of your client, instead of subjecting your client to an evaluation which may or may not be great. And you can select provide input in terms of the evaluator you wish to select. You can consult with counsel. There is a list of 730 experts. Talk to a supervisor. If anyone's requesting a 730, if you're new, you want to talk to a supervisor. You want to make sure you object if you don't feel it's appropriate and it doesn't relate to the facts of the case. It's not going to benefit your client. There's other things you can do. So I would advise you to talk to a supervisor about that. The next form I'm going to go over, you don't... Yeah.
You can't have an evaluation without the children's attorney's consent.
Well, I think the court can make orders. If the court wants the child to be evaluated to provide information, I believe that
But
the
not a
court...
secret one without the consent of the child.
Well, you can always consult with the child's attorney to determine if you want to do your own private evaluation. But with a 730, the court has wide latitude of disposition to make any orders it feels is necessary and appoint any expert. Sure.
So after this book was built, after 218, if the county council wants to do 730, I heard other attorneys saying like, oh, that's not a proper request, you have to file it to the EDA. Does that sound right? Or is it like you were asking for to change the case plan to make her do something that was not included, so you have to file through EDA?
Well, I believe that the county will argue that they're not changing, well, they're adding, they want more information and they feel that 730 would be appropriate. They can always make recommendations to the court. You can always object that you haven't been provided with notice, an opportunity to be heard. You would like to address these issues. But they can always make, the county is always going to raise those issues. You can always state you should file a 388. Absolutely. You want to make sure that you object to those orders if you're not in agreement with them. Consult with the supervisor though. The moment you hear county council requesting a 730, if you don't feel it's appropriate, object to it. Make sure you have the opportunity to be heard. If there's any change to the case plan, you should be provided with notice and opportunity to be heard and a time to prepare adequately. A lot of times, they would like a 7:30 evaluation when you have allegations of a mental illness. Those are the most common situations later on throughout the case. If a client was ordered to do a mental health assessment and they go to the Department of Mental Health, oftentimes they don't receive a complete evaluation and they're turned away. So that is often why county counsel will request a 7:30 later on in the proceedings. But discuss it with the supervisor and determine what your strategy is going to be. Sometimes some information is helpful, so just discuss it with the supervisor. The other forms that we have are the JV 180. That's a 388 form. It's not included in your packet today. What I would just note about those forms is that you need to attach the 183 and 184 to the back of the forms. Make sure you include all of your attachments, everything you'd like the court to consider. It's discretionary whether the court is going to permit any testimony, so you want to make sure your 388 is as complete as possible. Some attorneys attach points, authorities and support declarations, pictures, journals. Just make sure it's as complete as possible, and do not forget to add the 183 and 184 to the back of those forms. I have to mention the JV 800, the Notice of Appeal form. Always keep in mind whether you need to appeal any orders, word what you would like to be appealed as broadly as possible. Typically what I would do is I would state, for instance, on April 13th, 2016, the court sustained the petition and removed my child from my care. I appeal all jurisdictional and dispositional findings and orders made on that date. Just keep it as broadly worded as possible. On whatever date the court terminated my parental rights, I appeal all orders and findings made on that date. Just keep it very broad. You can also appeal other orders. I include a 388 if I filed a 388 and a 388 and 26 hearing were heard at the same time. You can appeal restraining orders as well, so that is something to keep in mind. Another form is a substitution of attorney form. It's an MC050. There are some forms that are miscellaneous, so you might want to look them up. Some of them have additional attachments and declarations you could use on the judicial counsel forms. With the substitution of attorney form, you are the attorney of record until you have filed the substitution of attorney and the court has relieved, you are the attorney of record until the court has officially made an order that you are relieved. So even if you filed it with the court, until the court actually accepts it and makes the order that you are relieved, you are the attorney of record until then. So just because you have it all signed, just because you've turned it into the clerk and it's been filed, you're still the attorney of record until the court officially relieves you. Make sure you keep a copy of the substitution of attorney forms in your file. Make sure that all counsel receive a copy of it and are notified about who the new attorney is on the case. And so make sure you make about 3 or 4 copies of those as well if you're requesting to be relieved and appoint new counsel. All right, so got a little bit of time here to discuss our next topic, which includes restraining orders. So, I have provided a lovely cheat sheet for you. Restraining orders are just they're so difficult, and most of us don't really want to fill one out. There's so much to it. Usually it's a fight. Sometimes you'll hear that the child's attorney wants a restraining order. If you do not file one, then the child's attorney is going to request removal. You're concerned your client's signing this under penalty of perjury. So there's a lot of issues with restraining orders. Also, not many people know what the burden of proof is for a TRO or for an order after hearing. So this sheet provides you with everything you need to know. It should, so, let's see here. So under WIC 213.5, that is where the restraining order section in our code book. That will provide you with some general guidance about restraining orders, but by no means does it mention anything about the burden of proof. I've heard every burden of proof, risk of imminent harm, irreparable harm. You are dealing with an injunction, so you hear all those sorts of things. Probably most of you will be surprised. The standard really depends on the type of conduct that's involved. So if you have a domestic violence case, your standard's going to be a little bit different than if you're accused of just harassing or making some general threats. So if it's related to domestic violence, you need reasonable proof of past acts of abuse for a temporary restraining order. That is the basis for a temporary.
What section is it?
That is actually going to be under, hold on 1 second. It's not under 213.5 A and B.
Family Code 6300.
Family Code 6300. And let's see here.